people. Hi.
Hi.
Oh, there.
Hello. Are y'all here on the DC 20-00413?
Yes.
413. Yes. Yes, ma'am.
Okay.
I think I'm on a different case. I'm on DC 19-10724.
I was told that was canceled. Let me find the email to make sure I'm not crazy. 10724?
Yes, ma'am.
Yeah, the coordinator emailed me 12/18 that it was canceled. I'm not sure why or anything, but you might want to call her to see.
Okay. Thank you so much.
Sorry, I wish I could give you more
It's
info.
okay.
Okay, you're
No
welcome.
problem. Thank you. Bye-bye.
Why did she get back on? Why is she getting back on? What just happened?
Afternoon, everyone.
Good afternoon.
Good afternoon.
Were you wanting to wait and talk to the judge or something, or just?
I
Why-
might be.
No,
Where are
I'm
we?
talking to Miss Kleist. Because
Oh,
I was just hoping we'd proceed with the hearing and be done.
okay.
I can give you whatever information you want, but
No, that's fine. I mean, you can just tell him that you didn't know it was canceled or something. Whenever. He
our
gets-
hearing, I got kicked off. So our hearing's been canceled.
Yeah, that's what I was telling you before. You're not here on the 20-00413, right?
No, I am.
Oh,
I'm
I
not.
thought
There
you
was
were saying
there's-
you are. Okay.
No, I am. There was another attorney, another female attorney that was for a different case that had been canceled.
Oh, okay. I'm sorry.
It's okay.
I'm trying to switch screens and working on something. So, okay, my bad. No, you're still going.
Okay. I was like, oh, okay, thank you.
Okay, miss.
Good afternoon, council.
Good afternoon, Your Honor.
good afternoon, Your Honor.
Let me move some papers around here and create a space for this case. More of you than I expected for this hearing. Is everyone here on 19887 Terry Cooley versus Methodist Hospitals of Dallas, DBA Methodist Richardson Medical Center?
Yes, Judge.
Yes, Your Honor.
And no,
Judge,
Your
I'm
Honor.
here on 20-00413 Burt versus Posh and America's Credit Union. Ms. Kleist, I see her on the screen as well. She's the complaining defendant. I represent the plaintiff.
That's Joanelle Burt versus Michael Pash.
Yes, sir.
All right, I have that set at 1:45. You're welcome to remain, or we can send you to the waiting room. But I ask that you mute yourself if you remain while we handle the one before you.
Thank you, Judge. Whatever you choose.
All right. Now I do want to say, and might as well say this one time with everyone present. First of all, welcome to the 95th District Court. This proceeding is being conducted remotely, but it is also being conducted in accordance with the open courts provisions of the Texas Constitution. For the record, I am on the bench in the courtroom of the 95th District Court. The courtroom door is open. Members of the public are invited in to observe this proceeding. Should anyone wish, there are no members of the public present. But we are open for business. Secondly, this proceeding is being broadcast pursuant to the or on the court's YouTube channel as a live proceeding. Should you have an interest, all courts that are utilizing YouTube for live streaming of proceedings in order to comply with the open courts provisions have links with the Office of Court Administration. You can go at any given moment, and the OCA's list constantly refreshes as to which courts are live and which are not. And you can click on the link and go straight to that court's YouTube channel. That creates certain issues. Recording of broadcast proceedings is expressly prohibited. Neither the parties nor the public are authorized to record, and that includes copying the live stream or copying the YouTube recording, absent an order of the court authorizing that. This court has not issued an order to that effect. And I must advise you, neither participants nor members of the public can record this proceeding. There is one record only that comes out of this proceeding, and that is a record maintained by the official court reporter of the 95th District Court, Ms. Rouse. Are there any questions about that? Okay, Ms. Rouse, let us call 19887 Terry Cooley versus Methodist Hospitals of Dallas, DBA Methodist Richardson Medical Center. May I have introductions of counsel?
Yes, Judge. I'm Andrew Skemp, SKEMP, for the plaintiff, and I'm the movement. It's a motion to compel written discovery.
Yes, I'm aware what the motion is. Thank you, Mr. Skip, and welcome to the 95th District Court. Mr. Bars?
Good afternoon, Your Honor. My name is Dwayne Bars, appearing on behalf of my client, Methodist Hospitals of Dallas, DBA Methodist Richardson Medical Center. We are the respondent.
Okay. Before we get into the motion to compel, I noticed that the response was filed subject to the motion to transfer venue. Is there a reason why that motion to transfer venue hasn't been set for hearing?
Your Honor, I would have to defer. I didn't come prepared to speak on that. I'm one of the associate attorneys. We can get that set. I'll have to communicate with the partner on the case.
If this case is going to end up in a district, I'm not prejudging the motion to transfer venue, but if this case is going to end up in a district court of Collin County, then I don't need to be making this court, the 95th in Dallas County, does not need to be the court making preliminary rulings on discovery, it seems to me. So plaintiff's counsel, can you enlighten Mr. Skemp, can you enlighten the court as to what the status of the motion to transfer is? And I know it's not your motion.
Yes, Judge. This case has been on file for at least 6 months. I mean, they filed the motion to transfer venue. I don't believe it's going to be set. I know I've asked about it too, if they're going to accept this motion, and they haven't indicated that. We have been trying to schedule depositions. We've done written discovery. So at this point, I don't think it's an issue. I think it just.
Counsel, hold on a second. The clerk wants to see me for something. I apologize, counsel. Yeah, you were saying you've asked about it, and what's been the reply?
That they didn't know, and that they would have to check and let me know, and I've never heard anything back on it. But substantively, this hospital is located in Richardson. It's across the county line. It's not in Dallas County. The corporation that owns it is incorporated in, well, their principal place of business is in Dallas County. I think venue is fine. So I think that's the issue. I mean, we don't have to rule on that, but I feel very confident that venue is proper in Dallas County, even though the hospital is located across the street, basically. But that's why they filed it. I would assume the only reason you would move it would be for the convenience of the parties, which, hasn't been raised. No one's ever nothing's been held up since the transfer of venue. We haven't been waiting to have that heard or anything.
Okay. Mr. Skemp, continue further on this then.
Yes, Judge.
Have you read, Mr. Bars, have you read the court's policies and procedures since that were issued since I was sworn in on July the 30th?
Yes, Your Honor. We have had an opportunity to review them.
You have?
Yes, Your Honor.
All right. Mr. Skemp?
Yes, Judge. I think so. I know I've checked it. I thought I checked yesterday, but I hope so. I think we tried to confer on it several times.
It's not an issue of whether you conferred. I'm just wondering, I pretty much lay out my opinion about discovery in those policies and procedures. And that is that a party is entitled to all relevant information that is not privileged, relevant being defined as relevant to a claim or defense. And of course, any discovery that may lead to the discovery of admissible evidence. Discovery is not a fishing expedition. I was 35 years practicing before I took the bench. My least favorite thing to deal with is overbroad discovery on either side, whether it's on my side as a propounder or or responding to that. Discovery that asks for any and all each and every, all in singular, blah, 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 that is any way related to is simply an overly broad request. Now, in light of that, is there any further discussion that the two of you wish to engage in before we address the actual interrogatories and requests?
I'm happy to talk to Mr. Bars again. I think that the discovery is narrowly tailored to my client and what happened, but I think everything we're asking for is relevant, but I don't think we're going for a lot of stuff that's way out of what this claim's about.
All right. Secondly, let me ask you, Mr. Skimp. You're
Sure.
asking, by and large, you're not saying they didn't respond to the objections, are you? I mean, to the discovery, are you?
No, they've responded and objected, and I've narrowed it down substantially. I mean, we put a bunch of numbers in there. I've narrowed it down to 2 interrogatories and about 10 to 15 requests for production to cover kind of like 3 or 4 different areas. So I've
All
narrowed
right.
it. I'm only asking for very specific things that I really need to do my depositions. But yes, they definitely responded, and we've conferred several times. They've supplemented several things, but not everything at this point, in my opinion.
Is Mr. Bars aware of the limiting that you have done with counsel?
Well, we can, everything that I'm going to ask the court to rule on is stuff that we've discussed substantively in our
All right.
conferring. I mean, a lot of those things I said, skip that. We don't need to do that. Let's go to these, the ones I care about, really care about.
All right. Let's address the interrogatories then real quickly. Which 2 interrogatories is it that we're addressing?
It's interrogatory 2 and interrogatory 4. And I have they supplemented these. They didn't supplement them. The supplementations aren't attached to my motion to compel. And the supplementations also didn't include the original objection. So I kind of pasted them together, and I have just one document that has each of the discovery requests that I want to talk about that might be streamlined that you can go through.
That's what should be on file rather than a 58-page attachment to your motion, which frankly is outside the local rules.
Well, I
all right.
apologize.
So what have they? Let me ask this: interrogatory number 2. I'm looking at it. I agree. You're entitled to that information. What have they not provided you?
Well, they've objected. There's an objection, and then their supplementation says that subject to the objection, the medical records contain a list of individuals who provided care to Terry Cooley. Defendant is aware of no other person that provided care while she was at the facility, and defendant reserves the right to supplement. And so my issue would be that it's not objectionable. If they're just going to say the only people that ever provided care are in the record, then they should remove the objection so I can rely on that. But they also haven't identified people who are no longer employed, because I think I can contact them, and that they're not under the control of the defendant, and that's the issue.
All right, Mr. Bars, what's defendant's response to that?
Yes, Your Honor. If I may give some context to this, when Mr. Skimp indicated that there were conferences, there were in fact 3 conferences that were held after Mr. Skimp threatened to file this motion to compel about these very issues. In those conferences, Mr. Skimp indicated that he reserved the right to reopen and revisit everything that was discussed. With that being said, to focus in squarely on interrogatory number 2 and interrogatory number 4, our position—
Let's deal with 2, since that's the one we're talking about.
Yes, Your Honor. With interrogatory number 2, we have responded. In our first response, yes, there were objections, but we directed the plaintiff and plaintiff's counsel to the medical records. In the first conference that was held on July 23rd, during that phone conference, I directed him to the specific pages in the medical record that identifies and outlines all of the healthcare providers that provided treatment to this particular patient. On the call, he started to go through those list of pages. It was 2 pages that I had directed him to. All of those individuals would, of course, be under the care of Methodist, which would be the contact information for my office if they wanted to get in contact with any of these individuals. The supplemental language that was provided, or the amended language that was provided on July 31st, was actually after going and speaking with Mr. Skimp for an additional time so we could try and figure out language that would be agreeable. And in that effort, he said, I don't know, send me some language. I'll see if I still need to file the motion. So our position is very clear. We've identified all of the healthcare providers that are responsive to interrogatory number 2. We gave him the patient medical record and we directed him to the specific pages, Your Honor.
Well, I noticed that you're being non-responsive even in your recitation there. It doesn't say healthcare providers, it says licensed staff. Now, you may be meaning the same thing, but you're obligated to respond to the interrogatory. It also, the interrogatory also requests that you provide the current employment status. I doubt that's in the medical records. That said, I suggest that defendant would be wise to read and comply with both language and otherwise Rule 172, subparagraph C. It's not just enough to say, see the medical records. And I'm not going to overrule your objection because I understand the objection. It could, and it may, but you are required to answer subject to that objection. And I believe you're obligated to provide a fuller response than what it sounds like you've done. So I'll order a complete response on interrogatory number 2. Mr. Skimp, as to number 4, please.
Yes, Judge. Number 4 is very similar, but this is broader. So definitely there's a difference between licensed staff as opposed to all personnel. And that's another issue, is that nursing aides, this is a bed sore case, nursing aides, people who are not licensed nurses or licensed therapists, a lot of other types of personnel in a hospital are responsible for doing a lot of the hands-on care of the patients. And so this interrogatory 4 is asking for all personnel that rendered hands-on care only to Mrs. Cooley. She was only in the hospital for eight days from December 29th to January 7th. And so but it's the similar, but just a different subset. And this is for all personnel.
Mr. Bars.
Your Honor, if I may, our position is still the same. We directed the plaintiff to the specific pages of the medical chart and went through them with the plaintiff. Again, even by plaintiff's own admission right now, he's saying that interrogatory number 4 is broader than what's being sought under interrogatory number 2. When we were reviewing and responding, we saw these 2 interrogatories really as one and the same because he's seeking the same information, which is why we have the same response, Your Honor. We've identified these individuals. We worked on language with the plaintiff after 3 conferences to address and get language that plaintiff would be able to rely on, that he has all of the names of the individuals, providers, personnel who interacted and provided treatment with this patient, Your Honor. Our position is that we appropriately responded to this.
Your Honor, can I just say one thing?
Now, counsel, I'll simply note the questions aren't the same. They're similar. They ask for categories of individuals. The response is largely going to, there may be a lot of overlapping people, but this one asks about all personnel. The other one asked about licensed staff. I mean, it is a different question. Again, if you're going to use the option to produce records, then defendant has to comply with 197.2C, and I'm going to order that you do so, and not by phone call, in writing with an interrogatory response. Is that
Yes, Your Honor.
Judge, one thing, he's saying that he referred me to certain pages of the record. There is a list, but it's not, they don't say that in their interrogatory. He told me on the phone, well, look at page 921 and 922. That kind of gives you a list of some of the people who were talking.
Mr. Skimp, let's not pick at each other, because I'm going to tell you that I've read more pages in medical records in my life than the two of you combined. I'm going to tell you the medical records don't tell half or some of what's being asked for in these interrogatories. So they're going to have to give you information in writing. They don't tell you the employment status of the licensed personnel. So you're going to get your answers if the defendant complies with this order. Anything further on the interrogatories?
No, Judge.
All right. How about the request for production?
Yes, sir. The first request for production is request for production 12, and it's dealing with the personnel files of the employees or personnel. And it's at the bottom, it says,
why are you entitled to employment to personnel files of employees?
well, we're limited to the personnel file of the people who provided care to Miss Cooley. And I think that the case law has said that personnel files are discoverable. I think they would be relevant to the care that's provided, in the extent that they are going to concern the training, the background, how this person was hired, how long they've worked there, have they been disciplined? Have they, what's gone on with this person that would be, if not relevant, definitely would be it could lead to relevant information in the personnel files as regards to the patient care. The care of people in a hospital or nursing home or any healthcare facility is only as good as the human beings that are in there doing it. I mean, the hospital is a big building, but it's really the people in there providing the care. And so in this scenario, I think it would be relevant. I have limited it. I would be, and I've told Mr. Bars this, if they would give me the personnel files, I picked out 12 people, 12 nurses who were documenting in the nurses' notes with regards substantively, like with Ms. Cooley. I said, give me these 12 people. I'll limit it to even further than what's in the scope of the question. And I would still be okay with that. I have the 12 people, I think, but at least, and also for a person, if we're going to depose, I'm assuming one of these people will be who we're going to have to depose some of these people. I think the personnel files are also important for that issue.
Well, Mr. Bars, I don't need a response. You've lost me on that. When you tell me something could lead to the discovery of admissible evidence, that's not the standard. It's reasonably calculated to lead to. And a personnel file is way overly broad. There's documents in the personnel file that you absolutely are entitled to have, but a personnel file, using that as the catch-all to get yourself on the home run, it doesn't even get you to first base. You got to ask for, if you want the employment application or the documents reflecting the date of hire or credentialing information that's in the personnel file, and I can go on and on and on, ask for those things, but not just give me the personnel file of everyone, a complete unaltered copy of the personnel file of each person ever encountering the plaintiff. It just doesn't fly. So I'm going to sustain the objection on that. You're going to have to redraft that to be more specific.
Yes, Judge. So the application, the assessments and
I wasn't saying the applicant, you got to be specific as to what you want, and then we can pick it apart. Yes, that is or that isn't, but the personnel file contains all sorts of stuff. That has no relevance whatsoever to the suit. And I'm not going to be the one stuck in the middle of where you can't decide what's relevant. So you're going to stick it to me 12 personnel files or 20 personnel files and ask the court to sit there and play in camera games on what they're going to get. Ask specifically for what it is and force the defendant to say, yes, we'll give you this, we won't give you that. But personnel files is too broad.
Okay, thank you, Judge. The next one is 13 is asking for the time cards or the punch cards for the people who provided care to Miss Cooley. And so we've limited to just the day she was there and the people who actually provided care to her. So we could see, they did produce schedules that show who's supposed to be on that floor in that section of the hospital. But I think the clock in to see if they actually showed up for work, when they got there, when they left, that could be relevant, or it would be relevant to the case and will lead to relevant information. So
how is the time card punch from an employee who's in another wing of the hospital the entire time that Ms. Cooley is a patient? How is that relevant to anything?
Well, it's not. I'm only asking for the people who were in her floor or her wing who were treating her, not for every person in the whole hospital. So only the days that Ms. Cooley was a resident or a patient, and only
that's not what your request asks.
yeah, it should be limited. I apologize.
And
It would be, usually I put something there that says it's limited to the floor or the section, but that's all of it. I mean, that's what I'm asking for.
Y'all need to work this out, because that is too broad. As written, it is.
Well, I can reissue it if that's what
All right.
Number 14 is asking for the job descriptions, which that is more narrowed down and specific, and for the year of 2019 in a list of specific.
All right. How does the job description for the administrator, the business office manager, the house supervisor, the nursing supervisor, how do their job descriptions for these people who are not even in patient care, how are they relevant to a claim or defense in this case?
Well, I think they are involved in patient care. Definitely the house supervisor, nursing supervisor, or director of nursing, they're responsible for the nursing staff, and I think it would be relevant. I don't know what's in them. So to say, why are they relevant? I don't know what their job description entails, but it could entail anything from care planning or monitoring the staff or checking the charts, or I don't know, but I think it's not asking for people who are, I think all those people will be involved in patient care. The administrator is going to be overseeing the entire facility, and what his job description is, what his duties are, I think could be important. We end up having to depose the administrator or business office manager in cases because of the whole issue of the budgeting or the staffing, and that's do they have enough staff, and how are they making decisions on allocating resources? Is it based on patient need, or is it based on some predetermined budget, and everyone's just got to figure it out? I mean-
You're digging a deeper hole on the lack of relevance here. He says this is a fishing expedition, and that's what it sounds like. I'm going to sustain the objection.
Well, so
next
the
one.
nursing staff, we can't get the job description for the RNs and LVNs and
You know,
CNAs?
you asked for, if you two want to sit down and say, yeah, I'll give you the nursing staff or not, then do that. But the request as drafted is every one of the things that he just described, and in his objection, as I'm looking at it. So I'm going to sustain the objection. Now, if the two of you want to sit down and work out a small set or a subset of discovery to produce responsive to that, that's fine. You are invited to do that. But when you start off with asking for the job description of the second person asked for is the business office manager, the job description of the business office manager, how does that, now I'm asking this rhetorically, how that would play into patient care absent an allegation, specific allegation that this patient was booted from the hospital when insurance ran out. Now,
Well, we've made an allegation that the management and the staffing and the budgeting were not properly done. That is in our petition, and I think that's relevant to the healthcare. And if we sued for that, it would be a healthcare claim. But okay. The next one is number 24. This is asking for in-servicing materials that were provided to the staff of the hospital with regards to pressure injuries or wound care, which is the treatment and issue in this case.
Mr. Bars, why is that not relevant?
Your Honor, our objections in this one are based more on scope than anything else. The reason why scope is an issue is, as plaintiff's counsel has already indicated, this patient was admitted to the hospital for a period of 8 days, and he is making a request in number 24 that's overbroad, that's more than the actual length of the patient's stay. Based on my calculations, it seems as though he's requesting weeks before, at least weeks before, this patient was admitted into the hospital and weeks after.
So are you suggesting that only the training materials that came out on the day she was admitted to the hospital and came out through the day she was discharged from the hospital are relevant? The training materials in the year immediately prior to her admission are outside the reasonable scope of discovery?
No, Your Honor, we're not taking that position, but the position.
That's what you're saying to me.
The position that we are taking is that he hasn't clarified what it is specifically that he's looking for. Again, he has highlighted number 24, and these requests, the in-service materials requests, are actually between numbers 23 and 26, Your Honor. Yeah. All of them have, the only difference really between these different requests is the time frame involved, Your Honor, and the scope of what he's looking for. With that being said, if he was being specific, saying he just wants wound care and that's what he's looking for the nurses, or gave some kind of specific indication of what he's looking for, we would be able to go back and provide it, because we understand he needs information to develop his case. At the same time, Your Honor, it, as pled and as written, it's overbroad.
I strongly disagree and will overrule your objection. 24 is about in-service materials for 1 year, a confined period of time related to pressure injury, skin care, wound care, and skin injury prevention. That is quite limited, very specific, the objection is overruled.
Yes, Your Honor.
I'm almost done.
Mr. Skimp, do you too think you can work out the remaining remaining production? You see pretty much where I'm going on this.
Yeah, I would say, can I do two more? Is that
Sure.
okay? Number 31. And so this is similar. It's for the policies and procedures, and they have produced a table of contents for a policy, for like an in-house policy. But within that, he gave me the table of contents. I picked out the ones I thought were relevant. They produced them, but within that set of policies, there's another policy that says, here's all the nursing policies. So within the hospital's policies and procedures, they say there's another policy that's about nursing care, and it says direct. Oh, that's the
All right.
wrong.
I'm not going to get into the middle of whether or not someone has produced something they haven't produced, because that's you're asking the impossibility of the court. They're obligated to produce all documents responsive to a request that's otherwise an appropriate request. And if you say something exists and they say it doesn't exist,
Well, I know it exists because from the Methodist policy, there's a policy called Mosby's Nursing Skills, and it says the Methodist Health System Nursing Department recognizes Mosby's nursing skills as the preferred clinical practice guideline and procedure. And it's an online, and the problem is it's an online repository that's not, I can't buy my way into, like, it's not available. There's no way I can access that. And so I've talked to him about this and said, we need these other policies. So all I would ask is an order on this one specifically with regards to pressure injuries or pressure or, prevention, that they provide the ones from their online repository, the Mosby's.
Mr. Bars, is this a publicly available document?
Your Honor, to be honest with you, I'm not sure if it's publicly available or not. I would think that it is.
Here's the answer. It's very simple. If it's equally available to him, point him to where it is. And if it's not equally available to him because it's protected by way of only hospitals can have the password to get it, then get it for him. It's that simple.
Thank you, Judge. The very last one is number 38. And it's just asking for all the medical records, and they've objected. I always compel this. I don't think you can object. I don't think it's proper to intersperse objection when we're asking for medical records of our client. And I just need to be able to rely on the fact that this is the whole chart. And I've had it happen to me so many times where people say, oh, I found this other document,
All right. But his objection is that this is a duplicate, that this is exactly a duplicate of a request for disclosure. And you don't get to ask for anything in production that's within a request for disclosure. So what's your response to his objection?
Well, number one is they object basically in their response to disclosure. They say, they don't just say, here are the medical records. I don't think the request for disclosure specifically it doesn't entail, it says if you ask a suit for personal injury, you're entitled to the, I have to look at it specifically. I don't think it's the same.
All right. I don't think it's the same either, but that's what he said. And y'all got to talk about these things. Mr. Bars, produce the medical chart, the entire medical chart on the plaintiff.
Your Honor, if I may.
It's that simple. Yes, you may.
Thank you, Your Honor. Our position is that we have produced the entire medical chart. The reason for, I believe, we updated our response on late in July to say that if we're given an additional document, we'll produce that because we understand that we have the continuing obligation to continue to turn over information. What has been disclosed in our request for disclosures responses, to our understanding, is the full and complete medical chart as far as we know it. So
The court does not need to be in the middle of this. Very simply,
I'm-
and I'm telling you both this. You have to turn over the entire medical chart. He's either got it or he doesn't. Y'all hash that out. It's really that simple.
I agree. They're objecting, and then there's no objection to this question. They can't, I mean, the objection just needs to be removed. That's all I'm asking for.
Your Honor, if I may.
You may.
Thank you, Your Honor. His position is that the objection itself needs to be removed. We have already represented in writing that he does have the entire patient chart, but the objection is still valid, which is why our position is that the objection stands. We have clarified our position on it and have done so in writing. I'm not sure what plaintiff's counsel is specifically looking for to say that he can rely upon something more than what we have already said now in court as officers to the court, as well as our written communications and verbal communications to plaintiff's counsel regarding the patient chart. He has it. He has everything. And if we find something else out, we're going to give it to him. That's our obligation.
Fair enough. I'm going to overrule the objection to the extent that it is used in any respect to permit the withholding of any part of this patient's chart. That said, y'all hash out whether or not you've got it. Otherwise, I'm sustaining the objection, but I'm overruling it to the extent that it is used to justify withholding part of this patient's chart. Understood?
Yes, Judge. I can do an order, and can we email it or e-file it? Or how would you like me to present?
Put it up by way of e-filing. If I need a Word version of it, I will I'll appropriately ask for a Word version. Be sure to show that it's your motion to compel is granted in part and denied in part.
Yes, Judge. Thank you.
All right.
I appreciate it.
My pleasure. All right. Y'all are excused. Have a good day.
Thank
You do the
Judge.
same, Your Honor.
Thank you. Okay, now we are here on Burt versus Pasch, P-A-A-S-C-H.
Yes.
That is 20-00413. Ms. Rouse, do you need a moment to do your paperwork, or?
I'm good. I already got it. Thank you.
You're welcome. All right. Counsel, again, welcome to the 95th District Court. You heard the recitation about the open courts provisions earlier, so I'm going to go straight to introductions of counsel. First of all, I'd like to hear from plaintiff's counsel.
Yes, Your Honor. My name is Guy Hall, and I represent Juanel Burt. This is just briefly, this is a case.
Ron, I just need introductions right now. And Ms. Kleist.
Good afternoon, Your Honor. Kelly Kleist on behalf of the defendant, Michael Pasch.
Very good. What are we fighting about that y'all had to file 180 pages about in violation of the local rules?
Well, I attached your responses, but it is with regard to untimely objections, Your Honor.
May I respond?
You may.
Thank you, Your Honor. Our response, I'm going to trust that the court's had a chance to look at it, but if not, our response is we're late. I admitted that. My client is a 90-year-old lady, and this is not an excuse, and I put that in my response to the motion to compel. It's a fact. And that's what got this case started. She's got dementia. We all know that there's a COVID thing. And in regard to getting this information together to respond, I was somewhat handicapped. Some of the requests, particularly the request for production, were addressed to a person by my name, but apparently something to do with a law firm in Mesquite. I'm not sure how it got lost, but I didn't get it until Ms. Kleist actually sent it to me. I understand about the e-filing and e-service. I got all that, but for some reason I didn't get it, and that helped make it delayed. As I was preparing my responses to the interrogatories and the request for production, along with request for disclosure, answer to motion to transfer, and other things that Ms. Kleist was visiting upon me, the time ran out, and that's just life. I've been doing this long enough to know how that goes. However, I was preparing my answers as if the time wouldn't run out. I wasn't planning on it running out. So there's a battery of objections, and Ms. Kleist apparently is objecting to my objections. I didn't follow through and provide no answers. You'll note in my exhibit number 2 to my response.
Mr. Hull,
Yes, sir, I'm sorry.
let's get down to brass tacks on this.
Yes,
You were late responding to discovery.
Yes, sir.
What was the due date?
I don't remember. It was 30 days from whenever. I got the answers to the request for production to her on July 1st, and my exhibit 2 verifies that, both by a copy of my fax as well as a copy of my Adobe, which tracked it, and both of them show July 1st.
All right. Here's what plaintiff's or defendant's motion says. You were served them on April 29, 2020. Do you believe you were served them on April 29, 2020?
On the request for production, I don't believe so. If it was the interrogatories, I could have been.
Ms. Kleist, how did you serve them?
They were e-served. If you go to Exhibit C, which is page 173 of our motion, it has.
I'm not going to
service.
page 173 of an
I'm just
attachment.
I can post it and share my screen if you prefer. It'll take a second, but he was e-served and we have confirmation of service. Both documents went in the same email.
By the e-service process of the state of Texas.
Yes, sir.
All right. So that would have made the responses due on May the 29th, 2020, unless that was a weekend or a holiday, in which case it would have been the next day. So he was 2 weeks late on one and a month late on the other.
May I respond?
Sure.
The documents were sent at different times. They weren't sent together, so I didn't calculate how late I was on the request for production, but I gave you the exact date in my admission in my response to the motion to compel.
Well,
they're both late. There's no question about that, but they weren't late at the same time, Your Honor. Not that that helps, but just so the court understands the situation. And again, I'm not making an excuse that my lady has dementia, and I'm trying to cooperate with that issue. It's a fact. It's not an excuse. It's just a fact.
Well, here's I think the point that that Ms. Kleist was trying to make. She's got the e-service file. Now I went to page 173 of the attachment. She's got the e-service indication that it was in fact served on you, and you didn't open the attachment. So you were anywhere, Ms. Kleist, he was anywhere from 2 weeks to, or 15 days to a month late.
Correct.
I'm going to tell you, this is something that should be handled by the two of you picking up the phone and talking to each other. But I'm also going to tell you that the Supreme Court has basically told us that until these emergency orders are eliminated, we are to extend every deadline for everyone who needs it, period, end of story. And I'm not going to use a 2-week and a 30-day late responding on discovery this early in a case as grounds to overrule objections generally. I mean, that's just, I'm just not going to, especially in light of all the emergency orders where the Supreme Court tells me every day, not every day, 22 times in the last 6 months, we've been told that we are to extend every order upon request, or every deadline upon request, blah, blah, blah. Even limitations, which I don't think the Supreme Court personally has the right to do, but the Supreme Court keeps telling me that. So,
Your Honor, may I respond?
You may.
And I understand what they said. To me, that's against what the rules say. He had 30 days. I was never contacted. He's never asked for an extension. I have phone calls, emails of mine are never returned. If there's open communication, somebody's sick, something, ask for an extension. Most of the time, I'm very willing to do something and to work it out. But there's been zero communication other than atrocious claims against my client. And then that's it, and there's a disappearing. So that's where my frustration lies.
I understand your frustration. I believe you now have plaintiff in a position where they're going to be responsive on this stuff. I'm predicting Mr. Hull will talk to you about this stuff and about discovery. And frankly, if he doesn't, then I think the two of you got to see my 2 cents on discovery of everything that's relevant, that's not privileged, that's within the scope of discovery.
May I
And that would
respond?
include very straightforward things, requests that are not attorney-client, that anything that is not between counsel and client does not deserve an attorney-client objection and work product.
Well, I know what the attorney-client privilege is, and Mr. Hull, provide her discovery. I'm not gonna do a general overruling of all your objections because you were late. But if I've got to go through and do these one at a time, and there's something like you're asserting attorney-client privilege on something that isn't even possibly attorney-client privileged, and you haven't done a privilege log on it, it's not likely to be a good response from the court.
May I respond?
You may.
In our exhibit that shows what was delivered, there were 70 pages of documents that were sent over and received. I did not fail to respond except where it said all of your exhibits that you're going to introduce, and that magic word all, in 4 months into the case, I don't know all of anything. The other thing that I didn't respond to, and I'm just telling the court, I'm being upfront with the court, had to do with all my billing records, because that does get into attorney-client privilege, and my client has dementia, and I don't think she would even understand if I said, well, would you give up the attorney-client privilege? You know, so I've got Or should I produce something when the court doesn't require me to create something to produce? And I don't remember the rules requiring that. So that's all my only response.
I can't order you to produce, to produce a document that does not exist. I can't order you to make something to respond to that production. You know, that's the rule.
Yes, sir.
If someone's asking for all your billing records, that only becomes relevant if you're going to be testifying in most cases. I mean, I can think of some cases where it might otherwise be relevant. And telling me you produced 70 pages may be meaningless or may not be. I don't know.
I understand.
The global motion to overrule all your objections because you were late is overruled. I'm not addressing the individual ones right now. The two of you need to sit and talk about those individually and whether or not there's been appropriate discovery in response to appropriate requests.
Well, it is always my position to supplement, and in every response, I said that I would.
Okay.
So I'm just letting the court know.
There needs to be a communication. That's where the problem is there needs to be an exchange of communication between counsel.
On the screen, y'all are next to each other, and that's why I'm going like this with my finger. That's the two of you talking, not talking through the court. All right.
Yes, sir.
Okay. And I will say this, one last, just a general, I don't believe that a discovery request asking me to produce everything I'm going to produce at trial is a proper request. And if I heard that one mentioned somewhere, I think that does involve my work product. Mm-hmm. Now, that said, I can order the parties to produce their exhibits.
It's all documents you intend to ask as exhibits, correct? It's something that's permitted under your standard orders.
All right. So, and it can be supplemented. So,
of course.
Yeah, y'all understand where I'm going on that.
Yes, sir.
Yes, Your Honor.
All right. Very good. Okay. I'm overruling the general objection, but I'm not addressing any specific objections at this time. Or no, I'm overruling the motion insofar as it demands or requests an overruling of all objections because they were late, but I'm not addressing the specific objections at this time. Does that make sense?
Well, I'm a little lost. It's her motion to compel, and she submitted an order wanting 10 days to redo everything, I suppose. Is that order sustained or denied?
The order's not being entered.
I'm not entering an order right now.
Okay.
That is, I'm telling the parties that the court will not overrule all your objections simply because they were late, but I'm not issuing a ruling on the individual objections. The two of you need to talk about them.
Okay. Okay.
All right.
All righty.
Very good.
Thank you, Judge.
You're welcome. Thank you.
And
let me add this too. The court has two new dockets that I've instituted. Now this would not have been appropriate for either, but I'm just telling you, if you got, I've got a submission docket Monday at 8:00. You can put anything that's a non-evidentiary hearing within reason on the, and the policies and procedures say what is appropriate for the submission docket. Doesn't require an oral hearing. Now, if someone wants an oral hearing, I'll move it off the submission docket onto a hearing docket. But if you want something ruled upon, you can file a motion and get it submitted instead of heard. The other thing is I've got a Tuesday morning general docket. I'm not doing it the 15th or the 22nd, but I'm otherwise here on Tuesday mornings in front of Zoom. You can get the Zoom meeting ID, and if the two of you are random example, Mr. Hull, you think this is objectionable. You're talking to Ms. Kleist and she thinks it's not objectionable, and the two of you want to just get an answer to that. You two can get on the phone and say, hey, Judge, is this producible? Is it not producible? I mean, I'm sitting here on the bench on Tuesday mornings, available at 8 o'clock, available for any of those kinds of things, agreed orders, uncontested orders, simple matters that y'all just want a ruling on, and the like.
Thank
All
you
the
very
details are
much.
in the policies and procedures that are on the court's website. All right.
Yes, thank you.
Thank you. All right. Y'all are excused. Have a good day.
Thank you, you too.
Thank you.